Hello, everyone. This is Gilbert Gelada. I'm talking to you here from Private Corporate Counsel downtown. This is Tufts on Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts. When it comes to taxes, he is the master and the expert. He can answer your questions. But remember, this is not a legal advice. This is just to give you more information and sources so you can be aware of what you need to do. You can always call him at 877-647-7887. Again, that number is 877-647-7887, or you can use the same number but dial 407. You can also email him at stufts@pcc.law. That's STUFTS at pcc.law. Hello, Scott. How are you today?
Good to be with you.
Good to be with you, too. And we are discussing, you said, misclassification and requiring worker incorporation. So what is that all about today?
Yeah, so we've talked before about how the IRS approaches worker classification and 1099s versus W-2 and employees, right?
Mm-hmm. Yeah.
So what we want to do is remind ourselves what the test is. The IRS uses what we call a categories of evidence approach. They use 3 categories of behavioral, financial, and parties' intent. They do that off what we call the common law of determining whether whether a worker is an employee versus an independent contractor. All right, so that's the test. Now, we also have talked about how the IRS is just one part of this, right? That you got the Department of Labor, Fair Labor Standards Act. You've got other types of federal laws that deal with whether you're an employee or independent contractor. We also have workers' compensation, state issues, state unemployment. So a lot of different laws concern themselves with employee versus independent contractor, right? Not just the IRS, right?
Yeah.
All right. So then we get into situations where, well, obviously, if something's called misclassification, that means you've not done it properly, right? Mm-hmm. So misclassification is something that the various agencies, whether you're the IRS or the Department of Justice, or in this case, the Department of Labor, can come in and take a look and say, hey, we think you've categorized a group of workers the wrong way, right? So what they'll do, though, in these situations is the wage and hour division or something like that can come in and take a look at how you've classified. And they would want to do that because, let's say, if you're independent contractors, you may not have a 40-hour work week, right? And you may not have to pay overtime. So obviously, the Department of Labor would be concerned about overtime and those types of things, right? So in the situation, what companies have done is over the years tried to classify their workers as either independent contractors or employee based on some test, advice based on a totality of the factors, and different tests have been created across the country. Mm-hmm. Okay, so what's important now is we can see that here in Florida. Their Department of Labor has come out, and this is in South Florida, has opened up an investigation to a particular company. It's one of the largest cases that has been brought, and it is looking at whether or not there was misclassification. Okay? In other words, a group of workers classified as independent contractors should have been employees. Okay.
Question about that. Now, does that involve also immigration status with workers? That's a totally different?
Be a different arm of the government that would worry about immigration status and those things. But again, these things can overlap. Right? Because you might have...
Yeah, that's what I'm talking about.
Right. So you might have immigrants working who also are misclassified.
That's correct? That was my
And they're
question.
not getting the pay and whatnot.
Okay.
But what's interesting is, and what we worry about here is what the investigation is looking at is there required training, right? And mandatory training of workers. Mm-hmm. If it is, then that's not really like an independent contractor. Because if you're in business for yourself, you don't need any training, right?
Correct. Yeah.
So they look and say, is the company requiring you to attend training and yet you're an independent contractor. Right? So it's not the end all, but it's something they'll look at, right? It's a factor. You see what I'm saying?
So they're calling them contractors.
Correct.
But they're training them as their employees. So
that doesn't look right.
Yeah, it doesn't look right for the company.
Correct.
And the question is, do the employees know?
Right.
Or they don't know, or are they? I mean, that's kind of tricky.
Well, and then it gets even more interesting, because what happens if the company requires the workers to create their own company? Right?
Oh, that's shady.
Well, think about it. If I say to you, I'm going to enter into a contract and I'll treat you as 1099, but as a condition of doing that, I need you to form a company so that you will look like a real company instead of an individual.
Interesting.
So this is
sure
the aspect.
People did that many times.
So notice all right, so you and I are in business. I come to talk to you.
Yeah.
Right? I am a businessman. I pull out a contract and I say, here's my draft contract. This is what I want. And you take it, you mark it up, right? And we negotiate. Okay? So that's one, right? You can see that, right?
That's one way.
Okay.
Yeah.
How about another way? I have a contract and I say to you, and you say, you want a job? And you go, yes, I'd like a job. And I say, well, here's a contract, right? Sign here.
Okay.
And you say, can I negotiate? And I say, no. You don't look like a businessman, do you? You look like I don't know. You're going along for the ride, maybe.
Oh, good Lord.
Right? Well, but the point being that
I got you.
Independent contractor means a negotiation, a opportunity to negotiate, right?
Yeah.
But a worker might not have that, right?
That opportunity to.
But if I'm independent, by the nature of it, I should have a different arrangement than the employees, right? Maybe I come and go when I want, right? Maybe I have multiple jobs, right?
So it has
You're
to
not
be
my only
clear.
contractor. I work for you. Here's my contract with you, and I'm over here with another contract over here, right? Correct?
Correct.
So what this is getting, though, is let's get to that next question, which is, I come to you and I say, okay, I'm ready to work. I want to do a contract. And you say, well, before you can, you need to form a corporation. It's starting to get kind of like, well, wait a minute. I might already have a business, right? So you're imposing it on me as opposed to me doing it as part of my business model. Make sense?
Yeah.
All right. So that's why.
But it sounds like it can get very complicated when it comes to.
Yeah. Well, and again, let's look at the words. Independent contractor. Did it say dependent contractor? No. Why does it say independent contractor?
And that's interesting. It's called that, and they still play with it.
Right. So I can negotiate and give up some of my independence, right? And then at some point I might go too far, or you might ask me to go too far. So it's a line drawing, correct? At some point.
So is the IRS drawing these lines clearly?
So
they don't.
All right. So in the past, 30 years ago, there was some litigation over what we call the 20-factor test. Okay. And the 20-factor test the IRS had was what everybody and all the accountants went by, right? Guess what none of the factors were?
Oh.
Intent.
Interesting.
Why wouldn't that be a factor? Shouldn't our intent of the relationship be important? Of course, right?
Yeah.
But they didn't have it as one of their factors. And someone said, I don't think that's right. I think that's got to be a factor. May not be the only factor, but it should be a factor. If we both intend to have an independent contractor relationship, right? That should at least be one factor. Agreed? So in the 90s, the IRS pulled out the 20-factor test and replaced it with a categories of evidence approach that had the 3 sections: behavioral analysis, financial analysis, and intent of the parties. So you notice this third prong was not like the 20 factors. It was a third prong. And with that third prong, they were giving the idea that that needed to be considered. So they improved the test in that regard, right? Now, what about factors? What happens if, you start counting factors? I got 11, you have 9. Should that be the way it goes down? And it's not the case. It depends on industry, depends on which type of job, it depends on how you weigh them. What happens if I say these 3 factors are more important than these other 17 factors, or in the, right? How do you weigh them? And the courts will get into that. Let's not weigh them evenly. We shift them. So pretty soon, when you're trying to analyze it, how do you get it right if you don't know how they're going to weigh it? So a person like me can come in and say, well, in that industry, here's kind of how they've gone about doing it. But even then, you don't have the certainty you need, right? And luckily for taxpayers and businesses out there, there's a section called 530, and I think we've talked about that before in a prior episode. So we have 530, and remember, section 530 is the one that says even if you get it wrong, if it's reasonable and you had good faith, IRS will not reclassify that business, as long as it's a good faith determination. And then there's particular criteria. You got to file all the 1099s, you got to do all that kind of stuff, right? So anyway, so back to what we talk about. So the big thing from today's episode that we're talking about is you don't want to force workers to form a company at the insistence of the contracting party, right? Of the business that's bringing that worker in. That's a no-no. And that's kind of what we're seeing in the DOL. I think a number of states outlaw that or at least work against that, right? So if I do it on my own volition, fine, right? That just changes the name of the contract, right? I might be an LLC, I might be something else.
But not to change it because the company
exactly required
forced you
to make it look better, right? To put some window dressing on
to
it.
their convenience. Yeah, you heard him, folks. If that happens, and sorry, before I go to that route, and what form are we talking about when it comes to this?
So we're talking about the form 1099 NEC form. It used to be 1099 miscellaneous, but it's 1099 NEC, which is non-employee compensation. And the corollary or the flip side of that coin is W-2, which is your W-2 form.
So we talked about these before, of course.
Oh, yeah.
But this is another way of tackling it. Well, folks, if you have any questions about that or any other matter regarding taxes or tax law, you can call Mr. T. Scott Tufts at 877-647-7887. Again, 877-647-7887. Or you can reach us at stufts@pcc.law. Again, that email to reach Mr. T. Scott Tufts is stufts@pcc.law. Thank you and have a wonderful day.